When the people in charge of fighting corruption are running a mafia of their own, who can you trust? We are back with another explosive day at the Madlanga Commission, and the House of Cards at IDAC is completely collapsing. Today, Deputy Director of Public Prosecutions, Advocate Adv Serunye, took the stand and dropped an absolute bombshell about former IDAC head Andrea Johnson. Serunye exposed a dark, calculated plot from inside IDAC to completely destroy crime intelligence boss Dumisani Khumalo. He revealed that Johnson deliberately sidelined senior prosecutors to push these highly questionable arrests forward. But the most chilling moment of the entire testimony was when Serunye admitted why he stood by and let this destruction happen. He looked at the commission and gave a jaw-dropping confession. "I didn't have the guts to tell Andrea Johnson she was wrong." Let that sink in. A top senior prosecutor was too terrified to stop a targeted hit job on high-ranking officials. In the explosive footage I am about to show you, we break down exactly how this plot was orchestrated and why IDAC was operating through fear and manipulation. If you are absolutely sick of this rot and want Andrea Johnson held fully accountable, flood the comments right now with Expose IDAC. Slam that like button, subscribe to Voice of South Africa podcast, and share this link everywhere before the media tries to protect her. Let's look at this jaw-dropping courtroom confession. Jabulani, roll the tape.
Pressed very strongly that we don't have that kind of case. Yeah. Can you just explain that? I appreciate that you came in, tried to be the voice of reason. And maybe Ms. Ramsame and Ms. Tlachwayo, if she does ever appear, will come and tell us why were they not discussing these things with you once you raised them, and why did they not warn their bosses and their investigators? But you hold a view from the outset after you brought into this matter, and you're consistent about it. And then when you get the opportunity to amend the charge sheet, you could have used the alternative to be the main count. You would have a debate about, but is this an IDAC matter, which is not the debate we're having now.
Yes.
But why do you appear to force a preca count in this charge sheet?
Yes. Thanks, Commissioner. I was not forcing it, Commissioner. I was not trying to please them. I speak my mind out. Everybody knows that. I was saying investigations are still outstanding. Cover these things up. But if the little that you have in the docket is believed, if indeed Mokwele's application was received on the 26th, then she ought to have been disqualified, and she was not. And if she's not disqualified, then she's being favored. By whom? By the panel, because the panel seats, they have all those 76 applications, then people are disqualified one by one for not meeting the requirement. But why is this one, which is received a day late, it gets to a point where she's shortlisted to top 5 and then to top 3? If her application was received a day late, it's collusion with the panel members.
Why do you keep saying if, as if there was no evidence when you were drafting this charge? No. It was something that you still wanted to be established?
No, Commissioner, it was there. I'm talking about the receiving of the thing late. Her application is date stamped the 26th. I'm saying if I were in the court, addressing the court, and the court were to believe me. But again, the one thing that was not there, one of the issues that I raised in one of my emails was, go and obtain the affidavit of the secretary of the panel, because that's the only person who can talk to when was this application received. And that was done after I had left the case, but I'm told that affidavit is there and the person confirms that the application was received on the 26th. Therefore, she ought to have been disqualified. And that is why I'm saying, if the evidence were to be believed, and that her application was received a day later, she ought not to have made it to top 5 and to top 3 and ultimately to top 1. And that is why the collusion. Section 20, I was still going to ask the questions that I asked. Where's the evidence to prove your corruption? But if I'm going conspiracy because I'm looking at these pieces of evidence that the applicant meets with one of the panel members a day before. They try to put her in the vetting system. They can't do that because she does not have a personal number. They then register her in a system called Inkwazi, which is meant for service providers. What do I call that? Looking at the evidence. She's colluding with one of the panel members, at least Ngube. If her application was received late by a day, it ought to have been disqualified. She's colluding with all of them. They conspired to commit corruption based on the evidence that was before me, and that charge made sense in that way.
How was an outsider like her supposed to be vetted then?
Sorry, Commissioner?
How was an outsider like her supposed to be vetted?
On the reading of these
Because you said, for example, because she was not on PESAL,
yes,
she couldn't use the vetting system used by those applicants who were internal within SAPS, that is. Yes. So how was she supposed to be vetted?
Only at the point where, if she had been appointed, the moment she's appointed after passing the interviews and she's appointed, then they give her about 6 months to do the vetting. In that 6 months, now she has a personal number. She can be loaded onto the SAPS vetting system, and then she does the vetting, or she can do a private.
Continue.
Sorry, Komsa. She couldn't use the SAPS vetting system because that you can only do when you have a personal system. Secondly, the use of the Inkwazi system, it's fraudulent in itself because it's meant for service providers.
But do you include her in that? Is she supposed to know anything about Inkwazi and whatever else if it's not Inkwazi? Is she supposed to know that?
I don't think she would have known that, but now she meets with one of the panel members a day before the interviews and taken through this, and she submits an application, and her application is processed. And based on
That's exactly my question. Is she supposed to know that that ought not to have happened? Because if vetting is mentioned and all of this is taking place, and from where she was sitting, that was an attempt to satisfy the vetting requirement, or not?
That's true, Commissioner. I don't think for her as a civilian, she would have known even the difference between the SAPS vetting system and the Inkwazi. But here's one of the panel members who's taken her through.
You see, my question does not relate to SAPS members. Yeah. It relates to her. Should she have known anything about any of this? That's what my question is about.
I doubt that she would have known. But if we argue in the matter in court, it's something different. How did she know that she has to avail herself at the office of Ngube, where she has to be taken to the vetting office for the vetting to be done before the interviews are done? Interviews are going to be done the following day, okay. and they can't do it.
Let's leave it there.
Advocate, you may not know this, but all the shortlisted candidates were given a letter to say they must make themselves available for the purposes of vetting. Yeah. So they were actually being disadvantaged because the advert said you must only do that 6 months after appointment. So whoever said to them, come and do it before the interview, was not benefiting them. They were actually disadvantaging the candidates. Because the advert, it's the one on 178 yes. file 2 that I took you to. When you do that, you're not benefiting the candidate. You are actually disadvantaging the candidate because you are subjecting them to a process that the requirements do not provide for. And it applied to, because it's that letter that General Khan even said, well, true. I don't know anything about this letter.
To me, really,
so if he let you page the document how is it that you say he wanted you to see its existence but not the contents? Because he could only have allowed you to page through the document if he had no problem with you seeing and reading its contents. So I don't quite get what you are saying.
I got a sense that he was rushing me. He thought I wanted to, because I've been asking about the 27. He thought I'll just look at, oh, there it exists, and then leave. But then I wanted to read the contents of this and see what this affidavit was about.
I may be belaboring the point, but if you go to page 19, you even say on perusing it.
Yes.
Lawyers usually use peruse when they mean that they read a document thoroughly. And you refer to perusing, and yet to suggest that you were almost not given an opportunity to read the document.
No, Chair, I read the document. I read it up to the last page because I wanted to see what was in this affidavit that I've been asking for since August, and no one is giving it to me. But when I finished reading it, I couldn't understand why this thing was being hidden away from me, at least, or from the team, because it was just a normal statement by Mr. Fadel Adams, which was very similar to the one which was in the docket, where he's saying he got the documents underneath the door, and making complaints about a lot of issues that were happening in the intelligence office.
All right, I interrupted you when you were about to read, right at the foot of the page, the last line. He retained the document in his hand.
Yes, last line of that page, he
Page
retained...
Page 18.
Yes, he retained the document in his hand, and I was not given a copy. The document comprised only of some 2 or 3 pages. It could be more. I don't remember because it's almost a year ago, and appeared to be a repetition of the complainant's statement containing nothing of substance. On perusing it, I observed what appeared to me to be an inconsistency in the commissioning of the document, in that the place at which it appeared to have been signed did not accord with the place at which it appears to have been commissioned. Like I said earlier, the deponent appeared to have signed the statement in Cape Town, but then there was a Pretoria stamp of IDAC, and then the commissioner of O2 would have signed there. And then I raised my concern with Advocate Latwayo immediately afterwards. I told her that she was going to have a problem with the Section 27 referral, because at the time I was under the impression that it was signed by the deponent at one place and commissioned by the Commissioner of Oath in another place,
Advocate Serunye,
based on the stamp.
is Mr. Perumalio Jr. at IDAC?
No, he's not. In terms of the structure,
Yeah.
He comes after us as deputies.
So, scared of. Was there a reason why you didn't tell him that, listen, I want that document, give it to me now?
Commissioner Khumalo, I did not think of making a copy because when I read the statement, there was nothing substantial for me. It was just like the other statements I've seen. So I thought at the time, why were they dilly-dallying from giving me this? Because there's nothing really in this. But we have a very good relationship with Mr. Perumal. I've worked with him many years ago in Kimberley. We did a case together there. So for me and him, he calls me brother. I call him Tony. So I was not scared of him. If I wanted a copy, I would have told him, Tony, please make me a copy of that. You know.
And give Advocate Latwayo a copy, because we are at discovery stage. The accused are asking for the docket. They are entitled to this document. It should be available. You are formulating draft charge sheets or amended charge sheets, and you were at a stage where you knew that the accused would be asking for discovery. You were at a stage where you are raising a concern with Advocate Hlatswayo. You're saying she's going to have a problem with the Section 27 referral. Why do you not insist that it be made available to her if you know that she must look at it because there are serious issues with it?
Yeah. Because, Commissioners, as I said earlier, there was a meeting where the ID called me and the two prosecutors, and I was told to back off from demanding this Section 27. The ID says, I've seen it. Are you not believing my investigators? So I was not going to ask for a copy of that because I got clear instructions. Stay away from this, just do your job and leave the...
So you were scared of the ID. That's why you did not insist that it be made available to the prosecutor.
If one, I cannot dispute that. I didn't want to upset her. She was clear. I have seen the 27. I'm satisfied that it exists. Leave this matter alone. I hear that you've been asking a lot about it. Leave this thing off. So when Mr. Perumal showed it to me that we were coming from a meeting, and I did not even demand a copy because I knew I don't have to deal with this document, but at least I've seen it. And again, remember, I was no longer part of the case, in fact, by then. This is now in October. I've since been recused in 16 September.
Scared of? Was there a reason why you didn't tell him that, listen, I want that document, give it to me now?
Commissioner Khumalo, I did not think of making a copy because when I read the statement, there was nothing substantial for me. It was just like the other statements I've seen. So I thought at the time, why were they dilly-dallying from giving me this? Because there's nothing really in this. But we have a very good relationship with Mr. Perumal. I've worked with him many years ago in Kimberley. We did a case together there. So for me and him, he calls me brother. I call him Tony. So I was not scared of him. If I wanted a copy, I would have told him, Tony, please make me a copy of that. You know.
And give Advocate Hlatswayo a copy, because we are at discovery stage. The accused are asking for the docket. They are entitled to this document. It should be available. You were formulating draft charge sheets or amended charge sheets, and you were at a stage where you knew that the accused would be asking for discovery. You were at a stage where you are raising a concern with Advocate Hlatswayo. You're saying she's going to have a problem with the Section 27 referral. Why do you not insist that it be made available to her if you know that she must look at it because there are serious issues with it?
Yeah. Because, Commissioners, as I said earlier, there was a meeting where the ID called me and the two prosecutors, and I was told to back off from demanding this Section 27. The ID says, I've seen it. Are you not believing my investigators? So I was not going to ask for a copy of that because I got clear instructions. Stay away from this, just do your job and leave the...
So you were scared of the ID. That's why you did not insist that it be made available to the prosecutor.
If one, I cannot dispute that. I didn't want to upset her. She was clear. I have seen the 27. I'm satisfied that it exists. Leave this matter alone. I hear that you've been asking a lot about it. Leave this thing off. So when Mr. Perumal showed it to me that we were coming from a meeting, and I did not even demand a copy because I knew I don't have to deal with this document, but at least I've seen it. And again, remember, I was no longer part of the case, in fact, by then. This is now in October. I've since been recused in 16 September.
Expect that the prosecutors would know that, but she can't be right. That it's an internal document, she can't be right, that it's not to be disclosed. Is that a fair proposition to make, that the prosecutors must know she's wrong?
Yes, but again, Commissioner Baloyi, I couldn't say to my boss, you are wrong, I'm going to disclose it anyway against your instruction.
You may, for your reasons that you give, not contradict her, but the fact is, as a matter of process, it means there's no full disclosure.
There isn't.
To the accused, and that has consequences. It could be any other document. From where I'm sitting, that if on something like this you have a head who says, no, we're not disclosing that, it's an internal document, and everybody around her knows that what she's saying is not correct, but they comply, then it doesn't give faith that on any other matter, if she says that we are not disclosing, that her prosecutors will not say, well, if I must lose my job, I'm going to lose my job, but my integrity and my responsibility to my profession and to the court is that I make disclosure. That has a sense of discomfort about it. And either she was particularly powerful, and so nobody dared to say, but that's breaking the law when we do that. Or she works with prosecutors who are okay to look the other way, which is deeply problematic, and I don't know which is worse. But that's the sense that, that a sense of discomfort.
I understand that.
That all of this creates.
I understand that, commissioners. Yeah, it's difficult to be in a position where I was at the time. I didn't have the guts to say to my boss, you are wrong, I'm going to disclose this, whether you approve it or not. I know there's going to be consequences, can be disciplined, that can be charged, and so on, especially that we have signed non-disclosure forms. So it was going to be, you disclose a document which we have told is an internal document, and therefore you're facing up to 15 years imprisonment for this. So it was that. But if you didn't say to me, don't disclose it, it was going to be part of all the disclosures. But we were told categorically clear, it's an internal document, you don't disclose it. And it is on those bases that I wouldn't have gone against her word.
All right, I've heard your answer, thank you.
Another.
That this is what happened in the lower court. Are you saying she's wrong when she says all of that?
Commissioner, what I'm saying is, indeed, she's throwing me under the bus in that she got me into the case to oppose the 63 bail amendment. But when she comes before the commission, she says something else, that as if I was doing things on my own. If she didn't instruct me to be part of the case, I wouldn't be sitting here today. She involves me in the case. I don't know what the brief to her was by Tlatrayo, but she says specifically, because there's a senior lawyer involved there, I want a senior person to oppose this. And if she was of the view that, no, you were not supposed to benefit from that wrong judgment, and her instructions to me were supposed to be, go back to the court, lodge an application in terms of Section 63, the state, be an applicant yourself, where you ask the court to amend the bail application. 63 allows either the accused or the state can bring that application. But she didn't say to me, or to us at least, go and amend the bail condition because we did not ask for it. She said, oppose the application. We do that. But in the back of my mind, I'm not following, I can't follow, I'm not going to follow a wrong or an irregular or an unlawful instruction. I've never done that, I'll never do that. In the back of my mind is, the magistrate was not wrong. The magistrate has powers to do that, but we're going to oppose. That is why, even when it went on appeal, again, with her blessing, we went and opposed it still. I engaged the High Court judge, took me to pieces. I tried arguing for my case. I did not get the first thing considered. I tried, and I said, this is what the law says, this is what the magistrate said, and these are case laws where I even referred the High Court to a case in Bloemfontein where an official of the NPA committed fraud against the NPA at the DPP's office, and one of the conditions there by the Magistrate Court was that he's barred from entering the NPA offices in the Free State. I raised that in our heads of arguments in the High Court, and that was confirmed in the High Court, where the High Court said those conditions must remain, and the magistrate must just add other conditions. So it happens. The powers are with the magistrate. It appears the IDAC wanted that condition. The head says to me, go and defend this. I can't say to them, no, why? And so I did that, and the amendment was abandoned, the application was abandoned. The Section 55 is brought in. Again, I'm giving instructions to oppose the Section 55 bail appeal. So I'm very sorry for the head to come before this commission and say, portray me as having acted on my own without consulting. It's just not true.
This charge sheet, who would have prepared it? I mean, I ask because in your note where you list the problems with it, you raise quite a number of issues, including somewhere where the charge sheet says accused one gave a gratification to himself, you know, under count 2.
Yes.
You raise those kind of things. Who prepared this? Who would have prepared this charge sheet? Did you get to find out?
Honestly, I do not know who prepared this charge sheet, Commissioner Baloyi. Like I say, the matter was already in court. I do not know who
But
prepared
at this point, when you get involved and the matter is in court, Ms. Ramsame you said Ms. Ramsame was responsible for this
She
matter.
was the prosecutor in the case.
So this is the charge sheet that she was working with.
That is
at
correct.
At the point.
Which was also disclosed to the defense, I would want to believe, from the date of the first appearance.
Yes. Well, I was saying to the chairperson, gratification seems to be your favorite, the IDAC's favorite fallback or default position. If you don't like someone, you charge them with gratification.
Not like that, Commissioner, but it's, corruption is a very serious offense that this country is faced with. So I guess we're all trying to root it out, but we follow the evidence as prosecutors and investigators.
Except in these two cases. I mean, we've had the debate about gratification, whether the charge the charge is properly formulated on your facts, and you've expressed your difficulties with it.
True.
The same discussion was had with the ID, the same discussion was had with Mr. Parayachi and Ms. Ramsame. So at least on these two cases, it seems to have been a default because maybe because nothing else works.
It looks like it, Commissioner Balo, it looks like it, and that is why, like, sitting here today, after listening to all the evidence, it appears, and I can see it now, that some of us went in, we were just doing our work, but it's painful that it appears there were things happening behind our back which we were not privy of, and it appears to me that some of us were used. If you're given instruction, go and oppose a 63, you go in, you think you're doing your work to the best of your abilities, you go and oppose a 65. I mean, I did 2 cases. Out of this case, I went twice to the High Court with the recusal application and with the 65 bail application, doing what I love, what I've been doing. In next month, it will be exactly 31 years, without knowing that there's other things happening behind the scenes. It's painful, but I didn't know at the time.
Thank you.
I didn't know.